What about Tom? Oh, Tom. تمام. مش هنيجي هو هو ازاي؟ لا خمس اسمع
ازاي فصل؟ تاخد الشمع. تاخد يفتح لي التايم ايميل الشمع.
كده.
تاخد دلوقتي. اه ده كل باشا شوف مسكت مساحة بس بتاخد الشمع.
تمام.
I've just sent a WhatsApp to Toma to tell her that it's starting. I don't have Tama's WhatsApp. Do you have it, Jonathan, to send her a message?
I'm in touch with her. I'm in touch with her.
Okay, because I've just sent Toma a WhatsApp saying the meeting is starting.
I think Tom is entering now in a few seconds.
Thank you. We have an issue with Tama. She has a problem getting in because of the her university site is blocking her entrance. So I have to connect through the Zoom. I hope she will in a few minutes. In the meanwhile, uh, uh, waiting. First of all, let's apologize for the delay of technical issues. We are to start in 2 minutes. Unfortunately, we have some technical issues and we 4 years, you can wait.
Okay, dear Jonathan, speak again. The sound was not perfect, so let's begin. I already see people from Lithuania here, Andra Mazrimaite, and probably Professor Toma is also joining us. So please, let's start.
Do you see the slide?
Yes, we see your slides. Yes, everything is perfect.
Okay. Well, the medical liability in the adversarial system versus system. So we're talking about 4 different legal systems. 2 of them represent the old adversarial system, the British law. Talking about Australia and Israel, and 2 legal systems that implement no-fault system and medical liability. Talking about Lithuania. So this is very interesting.
Jon, I can only hear half of what you're saying.
Yeah, I think if you take down your PowerPoint, your audio then seems to be a little clearer.
Okay. That.
If you speak now, I think we will be able to hear you.
Okay. So now you can also.
We can hear you perfectly.
Okay, so I will start to go again. We're talking about, well, first of all, welcome to this webinar. We're talking about medical liability in the adversarial system versus no-fault system. And we're going to hear tonight 4 different speakers that will talk on the different systems, 2 on the classical adversarial system derived from the British law, Australia and Israel, and 2 medical liability, that is in New Zealand and Lithuania. But first, let's start with Vuga's presentation. Thank you, Vuga, Secretary General of the WAML. Please, can you open the discussion?
Yeah. Thank you, Jonathan. Hello, dear participants of the webinar on medical liability. Good evening, good morning, good afternoon. In different time zones we are. I am from Baku. It is 11 p.m. in Baku, Azerbaijan right now. And I know that some of you are in the early morning in New Zealand and in Australia and in different geographic zones. That's why everyone, hello. As Secretary General of World Association for Medical Law, I am pleased and honored to greet everyone on behalf of the World Association for Medical Law, on behalf of the President, Professor Thierry van Zwilveld, Executive Committee and Board of Governors. We are an international non-governmental organization that unifies medical legal experts from all the continents, many countries, established about 60 years ago to respond to the challenge of legal and ethical nature in the fields of medicine, health, and life science. In 1967, World Association has been established, and we are meeting each other annually during last decade, starting our congresses in 1967, first 3 annually, then annually, and the last 10 years about annually. And our next meeting in Istanbul, a few months later, in August 2025, in the heart of Eurasia, beautiful Istanbul city in Turkey. We look forward to seeing you all, dear members of WAML and non-members but also to see your colleagues and friends who are interested in the questions rising on the borderline of law, medicine, bioethics, and human rights. There are so many platforms where medical legal knowledge and expertise may be exchanged, and the most important are platforms of science, education, medical legal practice, and health legislation. The main instruments of association to realize it in practice are our world congresses. It is Journal of Medicine and Law, WAML newsletter, and activities of the WAML committees, especially Education Committee. Education Committee of Association brings to discussion the most actual topics with inviting world-leading experts of the topic, and today's webinar about medical liability is an excellent example of such activities. Misdiagnosis or delayed diagnosis, failure to treat, prescription drug errors, surgical or procedural errors, childbirth injuries, and many other cases where parties are searching for truth, justice, professional conduct are happening everywhere. And today is opportunity to hear view of internationally recognized experts invited by organizers of event. Thank you, dear Andrea Pereira, my dear friend from Portugal, Chairman of Education Committee, and dear colleague, Professor Jonathan Davis, my colleague from Board of Governors of World Association of Medical Law, for leadership of this event, and my special thanks for our distinguished guests, keynote speakers, Justice Collins from New Zealand, Professor Tamar Gidron, but also for colleagues from Board of Governors, Thomas Birmontiena and Professor Roy Biran. Not taking much of your time, I announce webinar open and wish you all successful webinar. Enjoy the scientific session. Floor is yours, Jonathan. Thank you.
Thank you very much, Voga. We will continue. I want to thank everyone for joining us, and we will start without any further delay. Our key speaker tonight is going to be Judge David Collins from New Zealand. Judge Collins is a permanent judge of the Court of Appeal 2019 to date. He's a High Court judge from 2012 to 2019, and previous so Judge asked to present and this with System New Zealand. Please.
Can you now see my slides and hear me?
We can hear you, yes. The slides you can share.
You can see the slides?
Not yet.
Let me just go back then.
Perfect.
Okay, thank you very much. I'm sorry about that. It's a pleasure to be joining you again. I'll start with the origins of the New Zealand Accident Compensation Scheme. It came into force on the 1st of April 1974 and was the product of a Royal Commission of Inquiry chaired by Sir Owen Woodhouse, who at the time was a judge of the Court of Appeal of New Zealand. Fundamental to the establishment of the scheme was the proposition that the common law lottery of compensation for personal injury based upon proving fault should be replaced with a system in which the community accepts financial responsibility for all injuries caused by accidents in this country. There are 5 principles that underpinned the new scheme that was promoted by Sir Owen Woodhouse: community responsibility, comprehensive entitlement, complete rehabilitation, real compensation, and administrative efficiency. And these 5 principles continue to be reflected in the scheme today. It will be noted that the scheme is a no-fault scheme. That is to say, the focus is on establishing personal injury rather than on seeking to blame a person for the cause of the injury. And it replaces the common law tort system of compensating victims of injury. Those who do cause injury in New Zealand are immune from civil liability. Generally speaking, the scheme only compensates persons for physical injuries. There are some exceptions, but I do not need to traverse those. The scheme applies to anyone who is injured in New Zealand, including any visitor to New Zealand, and it compensates up to 80% of a person's income and provides for lump sum compensation and for personal impairment. The scheme places considerable emphasis on rehabilitation and getting injured persons back into society. It also endeavours to prevent injuries through education and safety programs. The scheme is funded through levies, principally the employer levies, motor vehicle levies, and government contributions. Through its investment strategies, the scheme has built up considerable reserves. Currently, the investment portfolio sits at about $47 billion, which in a country of 5 million is quite a significant sum. When ACC, the scheme, was first established, the principal concerns were motor vehicle accidents and workplace injuries. Injuries caused by medical treatment were also covered, but didn't receive much attention. Cover for medical injuries has undergone quite a lot of change since the scheme came into force. And I'm not going to traverse in this session all of those changes. I do want to say, however, that from 1992 to 2005, changes were made to the accident compensation scheme, which meant that it reflected more of an insurance model than a welfare-based system. And those changes saw introduction of cover for medical misadventure, and that concept was further subdefined to include medical error, which was in all respects the same as medical negligence. It was therefore quite contrary to the accident compensation no-fault scheme. That system continued up until 2005, when changes were made to cover treatment injury, and treatment injury is a much, much wider scheme than medical error. Now, proponents of the change to cover treatment injury believe that the best way of preventing accidents and to improve patient safety is by focusing on systems that locate the holes that are in the health system and focus upon fixing those holes rather than upon exposing and blaming individuals working within the health system. So I want to quickly bring up the definition of treatment injury. You will see that it is quite a broad concept. There is still the element of causation, which I will come to in a few moments. But it is designed to cover a broad spectrum of physical injury that might occur when a person enters into the health system or is receiving any form of treatment from a health professional in New Zealand. Now, what are the implications of this method of addressing persons who become injured through engagement with the health system? Well, there are many. Firstly, the cost of insurance for doctors and other health professionals. If a doctor can't be sued or a health professional cannot be sued, you would expect that their medical insurance would be quite low, and that is the case. In New Zealand, on average, it's around about $1,000 per year to be covered by organizations like the Medical Protection Society. But secondly, health professionals who fail to adhere to appropriate standards when providing treatment can expect to have their competence carefully assessed through a whole network of systems that have been now put in place to ensure that the standards of care are not compromised through the no fault, no suit accident compensation scheme. And I'll spend a few minutes briefly explaining those important backdrops to the accident compensation scheme. The first is was the appointment of the Health and Disability Commissioner in 1994. One of their first tasks was to develop a code of health and disability consumers' rights. And I'm not going to go through the code, but members of the public can complain to the Commissioner about the conduct of any health professional, and the Commissioner can investigate that person, and the Commissioner can, if the Commissioner deems it necessary, refer that person to a prosecuting authority called the Director of Public Prosecutions, who may prosecute the health practitioner before the health practitioner's disciplinary tribunal or other bodies, but I'll focus primarily on the health practitioner's disciplinary tribunal. The Health Practitioners Disciplinary Tribunal was established in 2003. It's chaired by a senior lawyer, and it comprises representatives of the public as well as the health practitioners' profession. It hears complaints brought by the Director of Proceedings or by a professional registration body. It has jurisdiction over 15 categories of health professionals, ranging from major professional groups such as nurses and doctors, through to members of smaller professional bodies such as occupational therapists and podiatrists and so on. The tribunal sits in public, and its decisions are almost always published, and the powers of the tribunal range from merely censuring the practitioner through to cancelling their license to practice. And sitting alongside the Health Practitioners Disciplinary Tribunal and the Health and Disability Commissioner are the various professional bodies. And they also play a significant role in regulating professional medical standards. For example, the Medical Council has a duty to ensure the ongoing competence of practitioners as members of their professions. Competence reviews may be initiated by referral from the Commissioner or other responsible bodies. And the practitioner, if they pose a risk of harm by practicing below required standards, will be carefully assessed, and the assessment may result in a remedial order that the practitioner undertake a competence program, or it could result in the impositions of restrictions on the scope of the practitioner's ability to practice. It may require them to be re-examined, counseled, or assisted in other ways. And if a practitioner fails to meet the requirements of a competence assessment, then limits may be placed on their ability to practice, including suspension. So in this very short time, what I wanted to do was explain that, yes, the accident compensation scheme ensures, amongst other matters, that health professionals can't be sued, because the focus is upon ensuring that those who are injured or who receive physical injuries through treatment are properly reinstated back into the society, and that they are compensated in terms of lost earnings. But alongside that is a very important network that ensures that doctors, even though they can't be sued, are nevertheless able to be carefully assessed. And I say doctors, I instinctively do say doctors, but I mean health professionals more generally, can be carefully assessed. If there are concerns about a practitioner, those concerns can be fully explored by independent, highly qualified authorities such as the Health and Disability Commissioner, by the Health Practitioners Disciplinary Tribunal, and by the practitioner's professional body. And through that network, we find that patients are best served through getting instant cover through ACC, getting instant rehabilitation without the need for prolonged litigation, and the safety of the community is reassured through independent professional disciplinary bodies, through professional bodies, and through the Independent Health and Disability Commissioner. Now, I know that Jonathan wanted to explore some specific topics, and I was quite happy to talk about those, but I wanted in this time to talk about causation. The fundamental elements of causation at common law still exist within the accident compensation scheme, but it has been diluted somewhat and is more closely resembles the Canadian model, so that the process works in the following way. Once a claimant adduces some evidence, it might only be slight evidence, but some affirmative evidence suggesting a causal link between their injury and treatment, then the onus goes on to those who are resisting the claim to try and prove that there was no causal connection between injury and treatment. So it's a hybrid model, not a strict common law causation model, but it serves, we think, the philosophy that underpins the no-fault accident compensation scheme, which is really designed to be inquisitorial rather than adversarial. So I'm happy to come back and answer the other questions in the question time, but that I hope gives you an overview of the New Zealand system. Over to you, Jonathan.
Thank you very much, David, for this very interesting presentation. Can you all hear me?
I can hear you, yes.
Good.
Yes.
Thank you. Of course, it raises many questions, and prior to this webinar, I forwarded a few questions to the discussion, which I will try and upload later when we discuss the differences between the different systems. So now, as we lack in time, I want to go and to the next speaker. That's Madron. We represent a between adversarial system, but about the common law classical adversarial system. But Amar will express no-fault system that specifically for road accident cases. Tamar Gidron is a professor of law, teaches a course at the University of Israel. taught the law. She served as the head of school of law in the Management College in Ramat Gan, Israel. So please, Tamar, present your presentation. Thank you.
Good evening, everyone. Can you hear me properly? Because I think I'm having a problem hearing Jonathan. Maybe because we are so close to each other. It's an honor to be here. And it was very interesting to listen to or to learn about the New Zealand legal system. And it reminds me that every year when I start my course on total, I explain how different is the Israeli legal system or the tort system in Israel from the New Zealand plan of compensation. So now I presume I know a little more of your interesting scheme, and I'll be sure to study more about the details of this very interesting scheme. Unfortunately, the Israeli tort legal system about medical law is quite the opposite.
Tamar, maybe you want to use the presentation mode so that the slides become bigger, if you want.
The problem is that I'm doing it from the college, and we have
okay. Yeah, it's okay.
problems.
Sorry, it's okay.
If I touch it, I'm not sure that I can get back to it. So maybe that's the only way to do it. So just to give you a quick glimpse about the place I'm staying in now. This is the Pratt College, and we are situated in these ancient buildings, which used to be hospitals. This, for example, was an English hospital. This one was the Hadassah Hospital, and this one was the Scottish Hospital, all of which now are looking like this modern campus. But you know, that it gives me a feeling of the connection between the theme we are talking about and the place I'm talking from. So let's start with the Israeli legal system. And I'll start by saying something very simple. We are all making mistakes. The problem we are facing in this presentation, or this medical liability issue, is who's responsible and why, and who pays the bill at the end of the day. And I'll start by explaining just in a few words the overview of the Israeli legal system, which is quite different from what I think all of you know about your legal system. Ours is quite different, and it's different because it's mostly a mixed legal system. We are all familiar with the common law system, which I'll refer to in a few minutes, and we are familiar with the civil law system. But Israeli legal system is a mixed legal system, and it's mixed in all respects. You can see it here in this slide. Israeli legal system is comprised of Ottoman law, of British mandatory law, of religious law. We have common law, and we have flashes of civil law, all in our Israeli legal system as a whole. So it's a very mixed legal system, and the system is also adversarial, of course, in contrast with the inquisitorial system. tort law, Israeli tort law, is still mostly common law and is mostly English common law. And the system is based on negligence. The only topic where in Israel we have absolute liability or no fault system is in car accident law. This is the only field where we use the absolute liability rule. All other liabilities in Israeli legal system, civil, is based on negligence or on fault. Medical liability is based or comes from Civil Wrongs Ordinance from 1944. It's a British mandatory ordinance which is still in force in Israel today. And if we look at the contents of this Civil Wrongs Ordinance, you can still see the traces of the British common law of that time. I mean, we are, I think, now more British than the British themselves because we kept this as an ordinance. And it's more difficult to change, even though the Israeli Supreme Court is very active, as you might have heard, and taking us sometimes to new places in legal liability or in tort law. But the basic rule is still the Civil Wrongs Ordinance and the negligence principle, which you all know, duty of care, breach, and causation. And I'll talk about causation in a minute. Here you can see, maybe this is the basic slide, the most important one, in which you can see stage by stage what you need to prove when you convince the court that there was a breach of duty and there was physical injury to the plaintiff. So duty, then the breach, causation is the real problem in Israeli law. Damages, quantification, you pay according to what you cause. Burden of proof is always on the plaintiff. We have two evidential rules according to which we can switch the burden of proof from the plaintiff onto the defendant, and then the defendant has to prove that he was not negligent. But this is only the unregular cases. In the regular case, the burden of proof is on the plaintiff from the beginning until the end. We also have the Patient Right Act. And what is most important about this act from 1996, which was supposed to be the Magna Carta of Israeli patients, the most important thing which I have to say about this, the Patient Right Act, is that it puts in the center the right to informed consent, autonomy. Autonomy is very important in Israeli tort law, in Israeli medical law. But at the same time, this important law doesn't have any explicit cause of action within the law. I mean, when you use this law in order to sue a medical professional, then you use the breach of statutory duty cause of action. There's no explicit cause of action within the patient's rights law. Autonomy. Autonomy is compensable independently in Israeli medical law. It's very important within the negligence cause of action. And again, it's protected within the patient's right law. Autonomy is very, very highly appreciated in Israel, and you can get a lot of compensation when harm to autonomy is is evidence. Causation. The Supreme Court deliberated long and hard on the problem of causation, and in most cases, the problem is that there are multiple causes, factual causes, that cause an incident in which the plaintiff is harmed. I'll take a minute just to give you an example of one of the most important cases in Israel. This is the case I want to refer to. This is a girl called Eden Malul. She's an Israeli girl who was born in Jerusalem some 20 years ago, and she was born with many medical problems due to complications during the pregnancy and the birth by her mother. And the problem was that her parents, her mother, couldn't show that it was the negligence of the hospital that caused this unfortunate defects of Eden Malul. The decision was that although the hospital was negligent because it took too long to decide to make a cesarean operation on this lady, although there was negligence on the part of the defendant, the Supreme Court decided that there's no liability because there were many other factual causes that could have caused this problematic outcome. Just to close this story about Eden Malul, this is the picture of her getting her BA at Haifa University. So just to give an optimistic view of the case, really one of the most important cases in Israel. About the burden of proof, I'll take just one moment to explain it. As I've already said, the plaintiff bears the onus of proof. Sometimes it's very difficult, but there are two ways in which the plaintiff can shift or try to shift or convince the court to shift the burden of proof from the plaintiff to the defendant. One way is basically according to the tort ordinance, if it seems that the defendant was negligent, so the court can ask the defendant to show that he wasn't negligent. And the other vehicle is an evidential loss rule, which is an Israeli invention, a rule which was started here in Israel. And according to this rule, which applies on all tort law, not only in medical law, and not only on negligence, it applies on all civil liabilities. According to the evidential laws, when the plaintiff can show that the defendant caused him to be in a situation whereas it's difficult for him to prove his case, then the court may ask the defendant to show that he wasn't negligent. The funding is liability. The funding body in Israel is the insurance companies. The court set the compensation sum, and unlike the no-fault regime, which is centralized fund and standard compensation, here in Israel, the plaintiff has to prove exactly how much he should be compensated. Again, when we look at the benefits, the cons and pros each legal system, and in Israel, the main issue is accountability. You were negligent, you acted unreasonably, then you have to pay. unlike the no-fault regime, as we've just heard. And the problem in Israel, as I know it, maybe Jonathan can enlighten us later, that hardly 25% of the medical accidents get litigated. Most plaintiffs or most patients don't sue. They don't go to court. Either they settle or they give up. And this is something that Israeli lawmakers should think about when they plan now a reform on this whole medical law regime. I think I've come to the end of my presentation, and thank you for listening. Back to you, Jonathan.
The notes of the
Jonathan, we can't hear you.
You can't hear me?
No, we can.
Can you hear me now?
Yeah.
Yes.
We have a problem. When you see my face, you can't hear my voice. So I better be my voice is probably better looking than my picture. So now we'll go to Toma is a professor at the Mykonos Romarius University Law School Institute of Public Justice at the Constitutional Court of Lithuania. Fields of research are constitutional law and health law. And Toma will be presenting the no-fault system of the medical system in Lithuania. Toma, please.
I see Andra from Lithuania. Andra, are you there? Andra was here. Andra Mazrimaite, you are here.
Yes, I'm here. Hello,
Are you
Andra.
with Professor Toma?
No, we're separately, but I called her and she said she will
No,
be
I
there.
am. I see you.
You are here.
You. I am here.
Wonderful. So the floor is yours.
Oh, thank you. So maybe there is a problem with some communication. So I would like to say that Lithuania has non-fault liability system for the patient's compensations, for the injuries of the patient's injuries compensation. Lithuania is a civil.
Professor
Yes.
Toma, can you
Yes.
put on your video?
But I am with my video. I can't understand why you don't see me. I am here. I had some problems with joining this webinar because it was a little bit complicated. I don't know why, but at least maybe you can. But dear Andra, do you see me?
We don't see your face.
We do not see your face, but okay.
Do you have a presentation, Toma?
I'm just delivering a speech.
Okay.
Speech. Okay. So we will hear you.
Okay, so let's look. No, sorry, maybe I will later try to join once more, but I don't know why it happens so. So sorry, dear colleagues, I will be very short. So Lithuania is a civil law country, and Lithuania also like, I know, also like Israel, we also adopted a law on patients' rights in 1996, but in that patients' rights, we also put and codified non-fault liability system. So Lithuania was very early, of course, New Zealand is much early, but we were looking then to the Finland, into the Finnish system. So from the very beginning, we decided that medical negligence will be just managed that way. But it was very difficult to start in Lithuania in 1996 non-fault liability system. So that's why there were problems and with financing and with legal regulation. And very quickly civil code, a new civil code was adopted. And what happened then? That in that new civil code, patients' rights were also codified. So then we had some kind of double system for a period of time and some problems. So all these things were managed only in 2019, and from 2020, the non-fault liability system in healthcare now is working in its full scale. So even now, when this system started to act, it was very important that the Supreme Court adopted several decisions, and in those decisions, the Supreme Court just proved those requirements, non-fault requirements in this compensation system. Because even after when that non-fault liability went into was active and was a living law, but nevertheless still there were a lot of hesitation, because before we moved from the fault system, from that classical civil system, compensation civil law system, to that non-fault liability. So the Supreme Court in 2023 proved that the pre-trial institution for handling disputes, so-called commission, is mandatory. So you can't go to the court if you are not using this instrument. And then the whole system is based on some principles. Damage has been caused to the health of the patient. Damage is not unavoidable, and damage has been caused in the course of the provision of healthcare service, and it is within a causational link. So these are the requirements, and these are the system, how it works. So how that system works, and are patients satisfied? What are the numbers probably? So if you look to the numbers, how that commission on non-fault liability works, I would like to say that 72% of, excuse me, do you hear me?
Yes.
Hello. Yes, because there are
Yes,
some
yes.
problems. So 72% of those addresses to the commission are accepted. From those 72 accepted applications, 30% of those applications go further, and they are positive, so they have positive outcome. 10% of those publications, applications still later goes to the court. Because in Lithuanian system, you have to address the commission for non-liability system to use. But after that, you have a right, if you disapprove with the decision of the commission, or you think that you are not satisfied, you have a right to go to the court, and then the full normal civil litigation will go on. So 10% of those who address the commission later, up to 10%, they are looking further. Now, how to address the commission? You have 3 years. For instance, because in medical care, of course, sometimes you can't catch the problem that you have after the treatment. But after the decision of the commission, you have only 30 days to address the cause if you are not satisfied. What are the numbers? What are the highest, maybe, money that people are gaining out? About 150,000 or 120,000. So in the year of 2024, the commission gave compensations for even more than, not close to 2 million, but much more than 1.5 million euros. Now, what are the problems that people are addressing? odontology, surgery, emergency service, then gynecology, and even family doctor. So different. So the list of cases when a patient can address for this non-fault liability system is really very wide. So this sometimes causes some problems because I have asked new colleagues from the Commission how they look, what are problems they are facing, and they say that the biggest problems, of course, are coming because still in Lithuania, even some kind of beauty surgery is also covered. And this is little, no, they think that it has to be maybe not under this scheme because it also takes some time and a lot of other things. Now the role of experts. Though the commission is rather small, only 7 persons, 7 people are working in the commission, but also they have a right to address to the experts. So experts are also delivering their documents. So under the decisions of the experts, also the decisions are adopted. The fund of the money? Where is the money? Who gives the money? The money comes from the social insurance fund, because everybody is just all institutions, all licensed physicians are paying to that fund. So sorry, maybe I'm taking too much time. If there will be any questions, I will answer. Thank you.
Thank you very much, Toma. It was a short talk, but it raises many questions. We will discuss it later on in the debate after we hear our next speaker, Roy Bell. And he will be talking about the role of the expert opinion in adversarial system. You know that in the common law, usually it's mandatory to prove the case through an expert opinion. In Israel, for instance, you can't claim for any medical argument without a medical
We've lost you again, John.
Stop video.
Much better.
Can you hear me now?
Yeah.
Yes.
I was arguing that in the adversarial system, I think the most important role for proving a case and the issue, especially the issue of causation, is through the expert opinion. So now we're going to hear about this important role of the expert from Roy Barron. Roy is a founding fellow of the Australian College of Legal Medicine, ACLM. He's also Australian governor and immediate past president of the World Association for Medical Law. He was previously a president, secretary general, executive vice president, and regional vice president. So he played many roles in the WAML. And the floor is yours. Roy, please present us your presentation.
Thanks, Jonathan. Now we will see whether we can make the slides work. And if we can, we've done particularly well. Let us see. It's looking good. Okay. There was much similarity between that which I'm about to say and which Professor Gidron said from Israel. I am the only doctor in the group of speakers today, so I can speak as somebody who has an interest in the role of the expert in the adversarial legal system. I have disclosures, but none of them relate to this meeting, and the messages I'm giving you are those of my own perspective rather than that of any other organisation. I also serve as a co-head of the Faculty of Educative Courses for the Australasian College of Legal Medicine, and I commend any of you who want to go to these to make contact with the college. But I have no conflict of interest and I'm not funded for this talk. The question starts with, why should we have an expert in the adversarial legal system? And the answer is that the lawyer will use the expert to determine and confirm what a viable case represents. The expert's role is to make that which is complex and beyond the understanding of the lay audience something that is intelligible. The lawyer selects the expert in most cases, though the court does have the potential to also select experts if needed. The lawyer will pick that expert which best suits the case that he or she is profiting to the court. It is imperative that the expert does not serve as a hired gun and should remain impartial. The way I present it is that the lawyer is the hired gun and the expert is the bullet used and fired from that gun. It is usually the case that the lawyer will know the views of that expert in the jurisdiction and area in which the lawyer is preparing a case, and then the lawyer will select that expert whom he or she thinks will best suit the case being presented. The expert is only allowed to contribute if the knowledge of the expert is required because that which is being presented is beyond the common knowledge of the adjudicators. To meet that standard, the expert must show that they possess the special learning, skill, training, and experience necessary to be able to justify the case being presented. It is the tribunal which will decide if there is a need or no need for experts, but in most cases, the expert will be allowed. Under Section 60 of the Evidence Act, the expert is the only one who can present opinions which will be accepted as facts. Under Section 136 of the Evidence Act, it may limit or exclude deficient reports, and we will touch on that later in this talk. Each jurisdiction within Australia has its own relevant code of conduct, which stipulates that which the expert must achieve. It defines the role of the expert, and that role is unequivocally to assist the court, not necessarily he or she who has called that expert. The opinions provided by the expert must be unbiased and must be fully justified and explained. And the obligation is to the court, not to the instructing lawyer. The opinion of the expert must define any assumptions made to underwrite the opinion. It must define any documents, material, literature, reports, and instructions provided by the instructing lawyer. And if providing external material, must provide references thereto. If, when the expert sees that which is required and feels that additional material is required to provide a suitable expert opinion to meet the needs of the court, that must be defined and sought. It is imperative that the expert acknowledges having read the code of conduct, but more than that, also acknowledges that he or she will abide by that code of conduct. The expert must confirm that he or she holds the necessary expertise, and that's usually provided both by the letterhead on which the report is provided, but also the expert is expected to provide an abbreviated curriculum vitae to show that they hold the requisite knowledge and skill to provide the opinion being sought. Under the Uniform Civil Procedure Rules, the party that has not called the expert can still demand that the expert be cross-examined. It is reasonable logic that if an expert is used and required, and even more so if a matter goes to court, then there is not a single opinion, but there is an alternative opinion, and that is where the adversarial system comes into play, because then two experts will present to the court, and the court will decide who is the more reliable and definitive expert. Often the lawyer who is instructing the expert will ask that nothing be put in writing until after a teleconference. Why? Because this avoids discovery. Discovery is the vehicle by which the other side can seek any written documents, and it depends on the jurisdiction what these documents include, because in some jurisdictions, any written material is discoverable, even if it is prior to the preparation of a report. Now, once the expert has been asked to look at a case, they should advise the instructing lawyer whether there is a case to be made, whether he or she is the appropriate expert to provide the right opinion, whether there is any missing relevant information that is required by the expert to complete that opinion. Once that has been provided to the instructing lawyer, the lawyer can then decide A, whether he or she wants to proceed, and B, whether they have provided sufficient material, and C, if they have asked the correct questions. The latter part is strictly the domain of the lawyer. Now, the expert, particularly in Australia, does not work for free, and there is a fee structure which is covered by the instructing lawyer, and that should be agreed upon before the expert accepts the case, so that everybody involved is clear and transparent. Once there is an agreement between the instructing lawyer and the expert, then we come to the preparation of the material necessary to take the matter to litigation. There are essential elements in the expert report. These include having read and abided by the Code of Conduct, having demonstrated sufficient qualification, experience, and training to be considered an expert within the parameters of the matter under jurisdiction and consideration. It must set out the facts and matters being assumed by the expert and differentiate these from matters of opinion, and if an opinion is provided, it must also provide the basis of that opinion and explain the reasoning behind it. As already stated, if there is reliance on external sources or literature, these must be referenced to allow cross-examination. If there is an opinion based on standards or guidelines, these must be disclosed. The arguments and reasoning provided by the expert must be lucid and allow the adjudicator to critically evaluate any conclusions that are proffered. And remember what I said, if a matter goes to court or if a matter comes to mediation and an expert is involved, there will be an expert from each side. So there will be conflicting opinions, and these opinions need to be considered, evaluated, compared, contrasted, and it is the adjudicator, if it goes to court, or the parties in mediation who decide what has presented or who has presented the most convincing opinion. It is worth stating that the better is the report, the less likely is it to go to court. Only experts can offer opinions rather than statements of fact. If the other side wishes to cross-examine a report, then they need to provide a subpoena and pay reasonable cost to go to court. Now, if the expert has to go to court, there are some fundamental rules that should be followed. Number one, the expert should take the prepared report and file and take these to the court, but it is court etiquette that the expert does not refer to these matters or these documents until seeking permission by the adjudicator, namely the judge. It is imperative on the expert to always be truthful and to answer questions succinctly, but it is also common sense that the expert should only answer the questions being asked. It is the lawyer who has developed the case. It is the lawyer who is the adversary, not the expert. And often the expert may not even understand why such questions have been asked or why other questions have not been asked. To speak too much as an expert in the witness stand could be quite destructive to the mode that the lawyer is adopting. It is not up to the expert to presume what should have been asked. That is the role of the lawyer. And if there is a problem, that should have come out much sooner in the initial teleconference between the instructing lawyer and the expert. A point I make is that often in very adversarial conflicts in court, the barrister who is opposing the expert may start attacking the expert's credibility as an expert. I argue very strongly that this is not an insult to the expert, but it is a compliment. Why is it a compliment? Because it is testimony when a barrister attacks a messenger rather than the message. It means that the message is so strong that the barrister does not want to attack the message and therefore wants to attack the messenger. And so it is a compliment to the expert, not an insult. When the expert is in the witness stand and cannot fully appreciate the tenor of a question, then he or she should seek judicial clarification and only respond once they fully understand what the question means. One of the issues that is very important for the expert is understanding court jargon. Such jargon includes words like, I put it to you, or you will agree with me. What that is saying is that under the rules by Brown and Dunn, if a barrister is going to bring an alternative expert to rebut that which the expert has said, then they must give the expert the opportunity to rebut that which is going to come. And so they will be told, I put it to you such and such to be the case. And when the expert hears this, it is obligatory to them to consider it, and if refuting it, to rebut it. It is not a compliment. It is telling the expert that under Brown and Dunn, there will be an expert who states exactly that which the barrister has put to the expert. The other comment in court jargon is with respect. What that is saying is that there is no respect in the matter, and they're saying, I think what you have said is a load of rubbish. This is often used also when the barrister feels that the judge has said something that's inappropriate, because it is contrary to the etiquette of the court for any barrister to refute the judge. And so they will say, with respect, Your Honour, And if they really feel angry, they will say something like, with the ultimate of respect. So what are the take-home messages? The take-home messages are, number one, the court has the authority to decide whether an expert is needed and only allow same if it is required to have special skill training or knowledge to make a fact more understandable and intelligible to a lay audience. The second issue is to establish the relationship with the instructing lawyer at the earliest point possible to provide an honest and open exchange with the lawyer, and that deals with understanding the matters provided, being considered an expert in the field, or alternatively, explaining who should be that expert, and always maintaining your own integrity and honesty when performing as an expert. In the adversarial system, particularly in Australia, it is only the expert who can provide an opinion rather than a statement of fact. This is particularly important for lawyers who consider hearsay, spoken material, not to be fact, whereas the expert can base opinions based on that which was told to them. There are a set of rules and expectations that are required for a report to be acceptable, and it is imperative that the expert adheres to those rules and expectations.
Roy, we're exceeding the time. We are exceeding the time. We are exceeding the time scheduled.
Yeah, this is the last slide, really. Be prepared to be called to court, recognize the etiquette, must be true to yourself, and handle everything with dignity. And that is the end of it.
Thank you very much. Okay. Thank you very much for all of you, all the speakers. And if I can summarize the issues, we have actually a clash. We have an understanding that the main issue that differs between the two systems is the question of causation and the no-force system challenges two main issues. One is the causation. When I talk causation, I'm talking about pre-existing or multiple causes due to complications, like we heard from Tamar's example of the case of Eden Malul. So the question of multiple causes, when we talk about medical liability, yes. And the other issue of causation, which we didn't hear any talk about it, is the pre-existing medical situation or medical history of the person who was injured, and how that is taken into account when you come to compensate or refund the patient. The other issue, of course, is the one of the experts. In an adversarial system, the experts are on behalf of the parties, and they represent the interest of the parties. In the no-force system, the experts are of the committee, and then there's a question of what is there consensus about the topic or the issue that represent the case? Is what we call I would say is there a consensus on the matter, or is this a professional dispute on the issues? also on medical responsibility and what are the standards of care. And there's a shift today from the old issue of standard of care to what is called evidence-based medicine, and how do you incorporate it into medical malpractice law? How do you incorporate it into the different systems? So now I'm opening the discussion to the debate of the public. I suggest that if anyone has questions to the speakers, they can raise their hands or put it on the chat, and I can let's debate the issues that we raised.
Jonathan, can I respond to a couple of the points that you have raised, which I didn't deal with in my talk? I did mention that we don't have a traditional common law causation model. There nevertheless has to be a logical connection between treatment and the injury. How that is established is often done through inference, but there is still plenty of room for expert opinion. And before the Accident Compensation Commission turns down a claim for treatment injury, it will have obtained medical advice and reports. And then if the matter goes to a court to adjudicate, there will be expert opinion on either side. As to the challenging question of pre-existing conditions, it is often very difficult under all systems to work out the role of a pre-existing condition and how it is exacerbated or added to an injury that occurs through treatment. But possibly the classic example is the failure to diagnose, the failure to notice the tumor. Now, we would, of course, instantly give cover for a failure to diagnose or identify a tumor. The fact that that's a natural condition doesn't preclude cover. Why you have cover is because of the inability of a health professional to identify the tumor and take steps that would normally be taken. And the fact that the person would ultimately possibly have died from the tumor does not necessarily preclude cover, because there will be a lost opportunity caused through the failure to remove the tumor. And I'm just giving a very basic example, I know, but I hope that illustrates and responds to as best I can the legitimate points that you raised.
Could I ask, David, could I ask you a question? What is the difference in what I presented in the adversarial system for the expert and that which is relative to the expert in the no-fault process?
There's nothing from the expert's perspective that is different. Interestingly enough, ultimately the court is going to have to be satisfied as to whether or not the claim meets the standard for treatment injury under the scheme. And that can be done through logical inference, even though that might not coincide with what the expert or experts are saying.
Does in the non-adversarial system, is there still a code of conduct for experts?
Absolutely, yes, absolutely.
Okay, can I, Toma? I saw you raised your hand.
Yes.
So please, can you put in your question?
I would like to join now, and you can see me at last.
Yes. Better later than ever.
Yes, thank you. So I would like to say that I do not see the problem with an expert, because in case of Lithuania, even lawyers are writing applications. When you are presenting that application to the commission, you can present your experts' evidences also. And when the commission asks for the experts, also the requirements are the same. And I think what non-fault liability, what gives, how to say, benefits for Lithuania, because it's very difficult to speak about all countries. So one of the benefits is that, first of all, if you are not satisfied with the treatment, you can handle it very easily, without lawyers, without money, even without assistance, because even the Ministry of Health and the Commission provides all kind of documents you have to fill. You happen to be a very specified person. And then Commission, of course, works with that material, and Commission asks the experts. So I think that in non-fault liability system, there is one possibility for people to handle it quickly. But of course, when I discussed with their colleagues in the Commission how they look, what are the problems, they say that very often people, when they address the court, because they want to punish the doctor, they are not only satisfied with the money. Because sometimes in Lithuanian system, sometimes courts gives you less than commission, and then you can have to give back some money. So this also could be. But in many cases in Lithuania, the members of commission say that very often we still feel some kind of fight against medical profession, fight against institution, and that compensation in many cases is a lot of, even much more moral. Thank you.
Can I comment to your a few things to what you said, Thomas? The issue of funding, yes. So if I understand it correctly, in the no-fault system, there is a substantial undercompensation in terms of money, and then this differentiates the adversarial system, where the basic tort issue is to bring back the injured person to what it have been in the eve of the injury. Yes, and if I can comment to the issue of experts, you know, it's not in the end of the issue of differences in opinion between the experts, and every expert has his own agenda, and the differences in the school of thoughts, and this influences also the decision of the committee, and how does the committee approaches the issues. And if I can combine that with what David mentioned about loss of chances, and the example he gave about the diagnosis of tumor, the issue of loss of chances to recover is part of the issue of causation, and of course you can't blame the doctor for the tumor, but you can blame the doctor for not diagnosing in time. But on the timeline, when this tumor was diagnosed, that affects the scope of injury, of course, and if it's fundamentally shortened his life, that in an adversarial system, that will affect the question of causation, and of course the question of compensation. So it's very, very difficult to, you know, the lawyers opposed to the doctors, they need tools to handle how do you money-wise the causation, and how do you money-wise measure the compensation.
If I can add a little bit regarding the money. But when we speak about the money, we have to bear in mind the patient. Because first of all, if the adversary system, then you have to start to pay to your lawyer. Then you go to the court, and then you're waiting and waiting and waiting, and probably the court will compensate your losses for the lawyer, for the whole case. In the non-fault system that we have, the first step is just you simply address and you have an answer. So in this case, if to look to those compensations, some of them for Lithuania is really very huge. I was really admiring that commission could give somebody 120,000. So it's really 150,000. So it's really a huge sum of money for Lithuanian, on the Lithuanian scale. So, but of course, I do agree that people, of course, they hope and they think and they value their health. And of course, they think that in many cases, maybe it's not enough of money. But in Lithuanian case, till now, only about 10% of those cases, they go to the court. So at least some of those people are satisfied with that compensations. Not at least some of them. So sorry for taking your time.
Thank you very much. So at this point of time, that we exceeded the time that we scheduled the webinar.
Roy. Roy wants to speak in Sydney.
I was just going to say that in Australia, you touched on a loss of chance. That is no longer a viable option in Australia following the case of Gett, that there is no head of litigation under loss of chance. It must come back to negligence, because loss of chance was used when you couldn't get negligence to get up. So the judiciary decided that loss of chance was no longer a viable option for litigation in Australia following the High Court decision.
Yes, we can continue speaking all night or all day for you. So now we are coming to the concluding summaries. Andre, the chair of the Educational Committee, thank you very much for organizing this webinar. We really appreciate it. And the last words are yours.
Well, since there are no questions in the chat, and to finish, okay, thank you. I just wanted, first of all, to say I'm sorry for the need to put a code. I think we lost some people because of the code to enter the Zoom. But nevertheless, this will be recorded and will be on Facebook and LinkedIn of the World Association for Medical Law social networks. And above all, I'd like to say this was a WAML moment, a moment of human rights in a controversy world. We need bridges of dialogue, and the World Association for Medical Law, founded in Belgium in the 60s, is one instrument of dialogue from New Zealand, Australia to Israel, to Lithuania, Portugal, and we have people from Brazil and from America here watching us, and many more will see this video in the next few weeks. I hope to see many of you in Istanbul in August for our annual Congress on Medical Law. The topic we selected for this morning, early morning in Sydney, morning in New Zealand, and late night in Israel and in Asia, and in Azerbaijan. Our Secretary General is in Azerbaijan. It's very, very late in Azerbaijan as well. Okay, was about one human right, the right to get compensation after a healthcare error. And that must be obvious to all of us that when you receive compensation, this is about human rights. This is what European Convention on Human Rights and Biomedicine states, the right to compensation in case of an undue error. Of course, we have seen adversarial systems in Australia and Israel. They are still the majority. We have seen no-fault systems from New Zealand and Lithuania. They are also gaining many support in many other countries. Thank you very much to the speakers, distinguished guests, Justice Collis, Professor Roy, and Professor Birmontiene, Professor Gidron, Dr. Davis, all good friends, and thank you to all of those who were also listening to us. And with your respect, I give the floor back to Jonathan Davis to close the seminar. Okay, we will close. Vugar Mamadov, as it's very late in Azerbaijan, so see you, many of you, in Istanbul. Thank you, Vugar.
Thank you very much.
Thank you. Bye-bye. Bye-bye.
Bye.
Thank you.
Thank you, Andre, for organizing it, and thank you, Jonathan.
See you.